Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, Honorable Supreme Court of India, two judges bench, Justice Surikant and J.B. Parthiwala, in the case of Sateesh Chandra Yadav versus Union of India 2022 in SLP Civil number 20860 by 2019 on 26/9/2022, just 2 days back, held that or observed that the employee can be terminated from the service if it is found that he has suppressed or he has given false information as regards his fitness or suitability for the particular post. You may be knowing, while joining, during the time of your antecedents verification, you will be asked to submit the verification form in form number 25. This form clearly asks information as to whether any cases are registered against you, whether you are arrested in any case, whether any cases are pending against you, whether any cases are disposed against you. All these things will be asked, and normally we also filled that verification form wherein we said no, because we are not involved in any cases. But there are certain people, if they are involved in any cases, definitely they have to give the information. If they suppress the information or if they have given the false information, even though they are working in the department to the satisfaction of the higher officers, definitely when the fact comes to light, they can be eliminated, they can be terminated, they can be dismissed from the service, and this is also upheld by the Honorable Supreme Court of India. Before I forget, I want to tell you one thing. Normally, you will be under the impression, suppose a case is registered against an individual, subsequently it gets acquitted, and then he gets a job. At the time of verification, he cannot say that there are no cases pending against him. He has to write that a case was instituted against him and it ended in acquittal. What for the verification is, please remember, verification is to know your antecedents, to know in which cases you are involved, to know in which cases you came out successfully. So now coming to the facts of this case, this man, Mr. Sateesh Chandra Yadav, he joined as a constable, as a police constable in CRPF, I believe, right, as a CRPS, and he is working from 17/1/2015, from Sankranti period he is working. But after coming to know from the district collector that he was involved in a writing case, that is crime number 1015 by 2008 under section 147. 147 is, you may be knowing, writing case 323, 324, 504 and 506, intimidation, causing hurt 323, causing grievous at 324. In all these sections, a case was business against him. So therefore, since he suppressed the material information that he was involved in a case, definitely after getting the report, the department terminated him from the service. And that too, the Honorable Court remarked that police duty, it is there to maintain law and order, it is there to catch the criminals, it is there to collect information, and it is there to nab the lawless people. But if you are becoming, if you are even involved in a case and you are suppressing the fact, you are also deemed to be a lawless person. Therefore, there is no leniency to be shown on him. He can be straight away terminated. And this termination has been accepted because he was terminated from the service. Right? Anyway, the High Court also allowed, agreed with his termination. Ultimately, the matter came to the Supreme Court level. Now, the advocate on behalf of Ms. Sateesh Chandra Yadav says that, please remember, even though he is involved in a case of writing, please remember, it is not moral turpitude. He did not harass any woman. He did not commit any POCSO Act case. It is only he was unnecessarily or he was falsely implicated in a case of writing. Writing means, you may be knowing, more than 5 persons. So in a group, he was involved even though he was not actually present at the spot. So please remember, so by mere suppression or the fact that he was involved in a case, it cannot be a ground to deny the so-called employment or to terminate from the employment. But the additional Solicitor General, he said, the suppression of material facts is sufficient to terminate his services. So this is where the doctrine of unreasonableness, administrative law method, so it comes into play. So the Supreme Court relied on the decision of very famous case, Avatar Singh versus Union of India, 2016. You can see it, part number 8, SCC 471. There they have discussed about Article 136. Article 136 gives wide or extraordinary powers to the Constitution, to the courts. So they should be exercised sparingly. They should be exercised only in exceptional cases. So please remember here, they have defined the police duty, which is an important duty. Now the advocate says that, no doubt, Your Honor, the case was pending in the year 2015 by the time he joined, but by the next year itself, the case ended in acquittal. But the point is whether a case is pending against him during his job. Yes. So Supreme Court did not show any leniency. Supreme Court is of opinion that it is a deliberate attempt on the petitioner to withhold the relevant information, and therefore dismissal is 100% accepted. So please remember, whenever you fill the verification form, you must be doubly cautious. No doubt you may be involved in a case. Write the fact, yes, and later the case ended in acquittal. Nobody will do anything with it. But if you suppress the information, this will be the result. With this, I am concluding. Thank you very much.